Hi, it's Mike DelSignore. I'm outside my office here in Dedham, Massachusetts, and I want to talk today about what happens if you're charged with OUI the case is going to be heard in Dedham District Court. It's a court I've handled a lot of cases out of, so I can sort of give you the lay of the land of what you can expect. So in this video, I'm going to talk about my experience in Dedham District Court. I handle OUI cases all over Massachusetts. So cases from Dedham could either be arrested by Dedham Police, State Police, Norwood, Wellesley, or Needham. So those are your main departments that cover cases out of Dedham District Court. So what will happen is, first thing I like to do is when someone's charged with OUI is I want to make sure we get any video evidence. One of the departments, Norwood, has video, but they're not forthcoming in disclosing that. If you don't request it, you're not going to get the video. And a video can be a game changer in an OUI case, because now instead of the officer's opinion, we have something objective showing that you appear to have good balance, good coordination. That video from Norwood won't have sound, but it's very helpful. Some of the departments actually have cruiser cam. Wellesley has both cruiser camera and booking video. So with that department, you're going to have video of the entire encounter. So that could be critical in the case. But let's start from the beginning of the case. So you're charged with OUI and you've gotten some paperwork, a blue sheet of paper, that's your bail slip. You likely have gotten other forms of citation and sometimes the alcohol influence report, so to speak. So your first court date is going to be arraignment. It's going to be a fairly quick court date. You'll enter a not guilty plea, get another date to come back for a pretrial hearing. At that pretrial hearing is when the government's going to provide us all the evidence in the case, so to speak. So from that stage, then we decide whether to put the case on for motion or for trial. So in some cases, let's say you made a statement about how much you had to drink, or let's say the cop is saying that they pulled you over for a lane violation, and you're saying, I didn't commit a marked lane violation. In some cases, we'll do what they call a motion to suppress, challenging the legal basis of the stop. Now, if we do that, then that's a separate hearing. You'll get a court date where the officer comes in and testifies on the legal issues of the case. That's always in front of a judge, but it's very valuable because even if we lose that hearing, it's a chance for us to have the officer testify under oath, and it supplements the report. So generally speaking, you come in your first court date, you're going to get a copy of the police report. That's the officer's version. You may have questions on it. We may have uncertainties. Well, what did he mean by this? What would he, what's the officer mean by certain things in the report? Well, if we have a motion hearing, we can ask the officer clarification. We can get more information from the officer about how they're likely to testify at trial. So I use those in many cases. It's a great strategy to try to lock the officer into our version of what your defense is. Now, the police report is just that. It's a statement of what the officer is likely to say at trial, but the police report is not evidence. So when the case goes to trial, the officer is going to have to testify live. In a lot of cases, the officer's testimony will be better than the police report. I've had many cases where the officers leave stuff out. Sometimes it's worse, and we can cross-examine them by pinning them to the report. If it wasn't in the report, then it couldn't have been that important. Officers are trained that if they don't put something in the report, it's like it didn't happen. So keep in mind that regardless of what the police report says, these are winnable cases. As someone who's never read an OUI report before, you may think it's a lot worse than it is. So when I go over it with clients, I'll tell them all the things they did right, all the things the officer left out of the report that we'll use in court and at trial to show that you weren't under the influence of alcohol. Let me give you one example of that. So if you pull over safely and immediately after the lights come on, that's probably not going to be in the report. But officers train that people under the influence of alcohol sometimes have delayed or slow responses to the blue lights. So that's a sign that you weren't impaired. It's often not in the report. When you're asked to get out of the car initially, if you got out of the car without any difficulty, without leaning on the car, using it for balance, that's another sign that you weren't under the influence of alcohol, but it's probably not going to be in the report. So they don't put what you did well in the report. They only put what you did wrong. So when I question the officer, I'm going to go through all those things that you did right based on my having the same training as the officers. I have their manuals. I know what they're looking for. I know how they're taught to assess these cases. Let's take the field sobriety test as well. Same thing. They're going to leave out things you did right. So typical report on a 9-step walk and turn will be the person was unsteady on their feet. They missed heel to toe. great report because there's a lot of things you did right. In a report like that, where it's very sparse about what you did wrong in the 9th step, that means you walked out the correct number of steps. You didn't stop while walking. You didn't use your arms for balance. And you kept your feet heel to toe. So there's a lot of things that that aren't in the report that you're not going to detect and understand that are key parts of your defense. So make sure that you don't overreact to the report and think that you got to resolve the case. If a lot of people call me and they're worried, and sometimes they want to resolve these cases without understanding all their rights and without understanding how the case would go at trial. Over here in Dedham, now Dedham District Court is probably stone's throw from here. It's about a 3-minute ride. Juries are very good in Dedham Court. It's a really good court. You'll get a jury pool from Norfolk County, and juries tend to understand that it's not illegal to consume alcohol and drive. You have to be under the influence of alcohol, and it's subjective. So all these things that the officers are looking for, it's very subjective. How you did on the field tests, you might have done, maybe you would have done better, but for nervousness, but for a medical issue. It will point all of that out. So don't rush into a plea, especially on a first OUI. There's no downside. If you go to trial and lose, you're going to really face the same penalty as if you pled out. If you took a breath test, keep in mind that I get these tests excluded from evidence routinely. They're not infallible, and there are a lot of different legal procedures where we could potentially get the results knocked out of evidence, meaning that the judge or the jury won't consider that result during trial. So when people are charged, that's question one is, can I win the case? Should I resolve it? And those are the things you should keep in mind, that these cases are winnable. You should strongly considering fighting the case. Next question people ask, when can I get back on the road? So if you took a breath test, you're suspended just for 30 days. After 30 days, you can get your full license back. If you refused a breath test, it's a 6-month suspension. You can appeal to the RMV in Boston. It's very difficult to win those appeals, so good chance that will be upheld. But there's another way to get your license back. If we can bring this case quickly to trial and you're found not guilty, then there's a presumption of reinstatement on your license. So those are the 2 license suspensions at play in most OUIs. If you crash and were brought to the hospital, you might not have a suspension for breathalyzer refusal or failing a breath test, because you probably were given a hospital blood test. There's no penalty for failing a hospital blood test, but you may face an immediate threat suspension of your license and will have to go to the Board of Appeals. So understand your license loss, the defenses to your case, the court process. These are sort of the big 3 things everyone should understand when they're charged with OUI in Dedham. I'm very familiar with all of these police departments. I've had a lot of cases here in this court. I've like practicing out of Dedham Court. I handle cases all over Massachusetts, but I wanted to specifically let you know what you should expect when you face an OUI in Dedham. My name's Michael DelSignore. Call anytime, 781-686-5924. It's never too early or late to call. My passion is to help people who have their backs against the wall, good people in difficult spots. Most of my clients are teachers, nurses, doctors in IT, every profession we've represented, and it's a pleasure to stand up for somebody and share their story, to put out, be their voice in court, and that's something that every day I work hard to make sure that we do the best job we can, and we've had great success out of Dedham Court. We'll do everything we can to win your case, and I'll be happy to help. Just reach out. Best way is by cell, 781-686-5924. You can text at that number as well.